ordinary farmer would be able to form an ICC. So not technically, but wherever there are 10 or more employees and there is a woman, one among them is a woman and she's facing any sexual harassment, then the word offsites means it complies. It applies to every such place where there can be a possibility of a sexual harassment. Now, it also includes Zoom calls and other online team meetings. This is very interesting because nowadays the work environment has become online. Everyone is now online because of the COVID situation. So C passes an inappropriate sexually colored comment about D's attire on a Zoom farewell party thrown by the office. D is extremely uncomfortable and asks C to stop, but they do not. D is confused whether the online party falls under the definition of a workplace to report it. Since the party was thrown by D's employer and D took part in the online party by virtue of their employment, the action of C will be considered as a sexual harassment in the workplace. So you cannot just start to comment inappropriately on a Zoom meet also. So let us understand what is this internal complaints committee. Under the Posh Act, the internal complaints committee are a group of people who look into the complaints of sexual harassment and come up with their recommendations to the employers about the consequences of the same. There should be a minimum of 4 people in the internal committee, and it should be headed by a senior woman employee and have at least one external member. Now, this requirement of one external member is obviously so that there is no blame of any partiality. The composition of the internal complaints committee should be informed to all the employees, including the contact details of the chairperson and the committee, so that the employees know where they can send their complaints in or who they reach out for any clarification. Another illustration is he has been subjected to sexual harassment in the workplace. They have filed a complaint. The internal complaints committee consisted of 2 people, E superior and HR personnel from the same organization. The constitution of this IC goes against the Posh Act. So what does this illustration tell us? That there has to be a person who is an independent external member, one who is not a member of the ICC. And that is why whenever such complaint is raised, the person whoever against the complaint is raised must also feel comfortable. If say I am the accused, I must feel confident that the internal complaints committee will do justice to me. Now, how do we file a complaint? Workplace harassment and sexual harassment. Let us understand that. It is important to note the distinction between workplace harassment and sexual harassment. This is very important to understand. A regular workplace harassment and what is a sexual harassment. Workplace harassment can exist in many forms and extend across caste, class, and gender barriers. Sexual harassment is conduct that has sexual overtone. And the discomfort exists because the person feels uncomfortable because of the sexual subtext. This need not be explicit and can also be implied from the circumstance, the people involved, their equations in the workplace, power structures, and the act itself. So another illustration here is F calls and messages G till late into the night to inquire about assignments and deadlines, even though the work hours end at 8 p.m. F continues to do so even after G tells them that the same is disturbing and invasive. There is no sexual overtone here. So this is a workplace harassment. I hope I am clear. Because in this, the person is asking about work-related issue. Now, this is a harassment, but this is a workplace harassment. Then another illustration is F, who is G's superior, calls and messages G till late in the night to inquire about work, proceeds to ask G personal questions about their life, their partner, and other details that G finds invasive. F also asks G on a date during these calls, even though G repeatedly requests F to act professionally. While nothing sexually explicit has occurred in this, this is a clear abuse of power hierarchy and a hostile work environment being created by a superior. Constantly asking a colleague out romantically after they have been clear about their disinterest and refusal amounts to harassment. That can be sexual harassment depending on the further acts and circumstances. So here the key difference is that the person is continuously asking the other side for a date and she is refusing. Even then, continuous repeated requests are being made. Then there is also something known as body shaming. You are an employee and another employee starts to body shame you or makes inappropriate comment on how you look, that you have suddenly gained weight, that you are looking, very, you are wearing very tight clothes and all those things. So these are considered as sexual harassment. So if I am suffering from any such kind of harassment at my workplace, where do I complain? A complaint has to be given within 3 months of the act of harassment taking place. It's very important. Usually, any complaint, see, a month has passed, 2 months has passed, you are not making any complaint to the ICC. Within 3 months, it is better that you make. However, if the IC feels that the person has a valid reason for filing the complaint at a later date, the same can be considered even after the expiry of 3 month period. In part 1 of this series, we dealt with the brief overview of the history of anti-sexual harassment in the law. How should I file a complaint? Is an oral complaint sufficient? The complaint to the ICC has to be submitted in a written form. In case the person giving the complaint is unable to condense it in writing, the IC is supposed to provide all reasonable assistance to make the same happen. It is also recommended that the complaint is exhaustive and contains all details to substantiate the complaint. If there is any evidence like screenshot, videos, messages, or any other evidence, it can be audio recording also. The same can be attached to the complaint and sent to the ICC. Now, does the presence of an IC or a posh policy mean that I can never date or have a romantic relation with a co-worker? This is a very important practical point. That if there is such a stringent posh policy, as per Vishayaka Guidelines, posh is designed, then can I never have a romantic relation or can I never talk nicely with my colleague? No, a posh policy in the IC exists to protect people from unwelcome sexual conduct. As long as there is consent, no coercion, and complete understanding of what the relationship entails from both parties, it will not amount to sexual harassment. With respect to asking out a colleague, a single polite request is acceptable. And if the other person does not reciprocate or agree to the same, they should not be forced or coerced further. If the relationship between two people in a workplace is casual, consent is the most important requirement. Now, this is the crux of this act. Consent is the most important requirement. Forced consent or half-hearted agreement to an act or a relationship cannot be considered consent. So, if you are a complainant and you feel that there was no consent from your end and you are being pressurized by your superior or your colleague, or even I can say to the extent of being blackmailed. Say, suppose you have done something, some mistake you have committed during your work, and somebody knows about it, and that person tries to take a disadvantage over you and says, since you have done so and so thing, I will inform everyone around in our office about this, and either you agree to what I say and comply to what I say, you come close to me or whatever, establish sexual relation, then such kind of a situation can come under the Posh Act. Now, sometimes it happens that there is a party thrown in an office and most of the people, are drunk. So, inappropriate acts while a person is inebriated cannot be condoned due to the effect of alcohol, and the same can be examined by the IC if a complaint is filed. So if you are in a workplace related environment, if you are in a workplace related party or annual function or whatever, and if you choose to drink alcohol, consume other things, then you have to be ready for the consequences and be prepared that whatever happens now, I will have to face the music. You have to behave appropriately or do not consume alcohol at all. That is my suggestion. In such a situation, it is better to be safe than sorry. Then there are various such. I just matched with a colleague on a dating app. Nowadays, there are dating apps. You can disclose that you are employed in the same workplace to that person if your place of employment is not mentioned in your dating profile. After that, if they still want to meet or continue the conversation, what was discussed in the previous question will apply. Do not take screenshot of the dating profile and circulate it internally or ask the person why they are on the dating app in front of other colleagues at work. This has the potential to create a hostile work environment and make them feel victimized. Some companies have mandatory HR disclosures if you are involved with a colleague. It differs from workplace to workplace. There is no such mandatory disclosure required under the Posh Act. So this Posh Act does not say that you disclose. But naturally, if say you are on a dating app and the other person, employee, is also on a same dating app and both of you are meeting each other, tomorrow you should not take advantage of taking screenshots of that dating app and say, see, this person is pursuing me. Disclose in advance to your employer. Exercise caution when you engage in romantic relations with interns and students. There are powerful dynamics in workplace relations. Some relations can be viewed as an abuse of that hierarchy. The ability of the subordinate to refuse sexual relation diminishes when the act is being proposed by a person who is an authority figure, who can influence their career and their position in the workplace. So, if there is a person who is very authoritative in nature, and that person is trying to put pressure on some subordinate for any sexual favor, that can come under this act. Now, what is the age of consent? So naturally, the age of consent is the usual age of employment, which is 18 years. Below that, if you employ anyone, it becomes an offense. You are prohibited from keeping children as your workers. So, age of consent in India is 18 years. Sexual relation with anybody below that age is considered as non-consensual, and the person can be charged under Protection of Children from Sexual Offences Act 2012. That is the POXO Act. If they have any physical relation with that person below age of 18. Can I also file a complaint with the police if I file complaint to the IC? Yes. See, it depends on the gravity of the situation. If you have been sexually harassed to a very different kind of level, actually, before this act came in 2013, Indian Penal Code pre-existed and it covered a few sections. I will quote such sections now. The usually known section is 354. Now, 354 of Indian Penal Code says assault or criminal force to woman with intent to outrage her modesty. Now, this technically has a wider connotation. It encompasses all places, not only a workplace, but everywhere, even in homes and everywhere. So, whoever assaults or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty shall be punished with an imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 5 years and shall also be liable to be fined. So, this is an assault or criminal force. Now, gradually, this 354 was enhanced and 354A was added. This 354A was inserted by Criminal Law Amendment Act of 2013. 354A says sexual harassment and punishment for sexual harassment. A man committing any of the following acts: 1. Physical contact and advances involving unwelcome and explicit sexual overtones. 2. A demand or request for sexual favors. 3. Showing pornography against the will of a woman. 4. Making sexually colored remarks shall be guilty of the offense of sexual harassment. Any man who commits the offense specified in clause 1 or clause 2 or clause 3 of subsection 1 shall be punished with a rigorous imprisonment for a term which may extend to 3 years, or with fine, or with both. Any man who commits the offense specified in clause 4 of subsection 1 shall be punished with an imprisonment of either description for a term which may extend to 1 year, with fine, or with both. Now, one thing that I just noticed here is the word any man. Now we are in an age of proliferation and acceptance of LGBTQ. So that makes me think whether this act needs further amendment or not. Because everywhere, any man, any man. Nowadays, because of the LGBTQ, anything can happen. So maybe in future, this act 354A may be further amended. 354B is assault or use of criminal force to a woman with intent to disrobe her. So if such a situation arises of a sexual harassment in a workplace where a person of a higher hierarchy says, no, you must disrobe yourself, that comes under this IPC 354B. Then voyeurism. Any man who watches or captures the image of a woman engaging in a private act in circumstance where she would usually have expectation of not being observed either by the perpetrator or by any other person at the behest of the perpetrator, or disseminates such image, shall be punished on first conviction of imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 3 years, and shall also be liable to fine and be punished on second or subsequent conviction with imprisonment of either description for a term which shall not be less than 3 years, but which may extend to 7 years and also be liable to fine. So this is added under 354C, voyeurism. Then there is another thing that is newly added, and I think it is the need of that, that is 354D, called stalking. So even at a workplace, there can be a situation of stalking. Unknowingly, another employee is following you everywhere, is stalking you. And gradually you come to know that someone is behind me and this person is making keen note of where I'm moving about, what I do in life. Unwanted nosing of any person in your life. Any man who follows a woman and contacts or attempts to contact such woman to foster personal interaction repeatedly despite a clear indication of disinterest by such woman, or monitors the use by a woman of the internet, email, or any other form of electronic communication, commits the offense of stalking. Now there are certain exemptions also given in this. Whoever commits the offense of stalking shall be punished on first conviction with an imprisonment of either description for a term which may extend to 3 years. So you have a lot of protection in IPC also. There is another section in IPC. I'll just bring that out. That section is section 509. 509 is actually, I think, which would encompass this entire Posh Act. Word, gesture, or act intended to insult the modesty of a woman. So whoever intending to insult the modesty of any woman utters any word, makes any sound, or gesture or exhibits any object intending that such word or sound shall be heard, or that such gesture or object shall be seen by such woman, or intrudes upon the privacy of such a woman, shall be punished with a simple imprisonment for a term which may extend to 3 years and also with fine. Now, there was a very famous case, the case of Rupan Deval Bajaj versus KPS Gill, 1995. The act by the accused of slapping on the posterior of a lady IS officer in the presence of gathering comprising the elite of the society, when considered in the light of sequence of events involving overtures, words used and gestures made prima facie, amounted to commission of offence under section 509 by the accused. There is another one, misconduct in public by drunken person. This does not necessarily imply to a woman, but as I earlier said, you cannot be intoxicated in a company or your employee party and take the risk. So that is under 510. So these sections which I quoted, 354, 354A especially, and this 509 of IPC, they are covered. So we are coming back. Can I also file a complaint with the police if I complain to the IC? The victim can also file a police complaint, and the IC is required to facilitate the same. The victim can pursue both IC complaint as well as the police complaint parallelly. So it's not necessary that you just file with the IC. If you are feeling that the offense is of a serious nature, go to the police. After the Nirbhaya incident, India's criminal laws that were drafted during the British era were amended in 2013 to include new provisions that make the acts of stalking, barbarism, and sexual harassment as criminal offence under the Indian Penal Code, which I just read. Now, what does the IC need to do? Suppose they receive a complaint, the IC should forward the complaint to the person against whom the complaint is given within 7 days of receiving the complaint under the Posh Act. They are given a window of 7 days to immediately inform the person against whom the complaint has been received. Then the IC can ask the victim if they want to opt for a conciliation. This is a process where the victim, the person against whom the complaint is given, and the IC members sit and discuss the issue to see if there can be any resolution. Say suppose there is a misunderstanding. A comment has been passed and there is some sort of a miscommunication and there is a misunderstanding. In such a situation, this is a very beautiful provision given here of conciliation. In some cases, the victim may want an apology to put things behind them and move forward. Money or monetary settlement cannot be used to close the conciliation proceeding. Suppose someone offers, I will pay so many lakhs to close this. It doesn't happen. If conciliation does not succeed or the victim does not opt for it, the IC can move on to the inquiry. What will happen during this inquiry process? The IC will speak to the victim, the person against whom the complaint was given, and the witness from both sides. The IC will look at the evidence presented by both sides. The proceedings of the IC will be recorded as well. So there is much more flexibility here than when you go to a police. Usually when you go to any police station for any complaint, say you have a complaint under section 509, the police do not record any statement. They, not visually record. They record means they make you write and sign. Here the proceedings of the IC can be recorded as well. The IC will have to complete its inquiry within 90 days of receiving the complaint. So a window of 90 days is given. Now this is a very good thing, because when usually any complaint is gone to any court of law, we all know there is a possibility of any case going on for years. So a 90-day window has been given to complete the inquiry by the IC. The IC then forwards its finding in the form of a report along with the recommendation about the punishment if the person is found guilty to the management, who will then implement the IC's report. The finding of the IC will be sent to the victim and the person against whom the complaint is given. So both are informed what is the decision taken by the ICC. What can I do while the complaint is being considered by the IC? I feel uncomfortable working in the same space. The IC can provide interim relief to the victim, including providing leave of up to 3 months. This will be in addition to the leave that is already available. Restraining the person against whom the complaint is given from entering the workplace, or transfer either a victim or the person against whom the complaint is given to another branch so that the two of them do not work in the same premises. In case the person against whom the complaint is given is the victim's superior, they can transfer them to another team to minimize contact. The IC and the management should also ensure that the victim's work performance decision pertaining to their bonus or other subjective evaluation is not done by the person against whom the complaint is given while the complaint is pending. Because suppose your person who is evaluating you is the person against whom you have filed the complaint, that person will not give you correct work performance. Can I post about what is happening in the IC inquiry on my Twitter or Instagram account? Absolutely no. Say a complaint is pending inquiry with the ICC and you have the urge to go on Instagram and immediately post things. Don't do that, because from start to finish, the entire ICC proceedings are confidential in nature. This includes the victim also and also the person against whom the complaint has been made. Even the witnesses have to resist. Witnesses, the members, the stenographer are supposed to maintain confidentiality and not publish, disclose, or post about this on any forum or to any other person. Now, having understood this, what if I cannot prove my complaint? I am a victim, but I am unable to prove my complaint. What happens to me? Acts of sexual harassment occur mostly in closed and intimate settings. In many cases, it may not be possible to prove that it occurred at all. Inability to prove the complaint does not mean that the complaint is false or invalid. However, if evidence in support of the complaint has been fabricated, or if the complaint is found to be malicious, then the internal complaints committee can proceed to take action against the person who has made the complaint. This will not be an extension of the current proceeding. The proceedings against the person who has filed the false complaints will start afresh. Now, what is to be understood in this? Suppose you are working at a particular company and there is some internal rivalry between you and somebody, and you start to fabricate things. You concoct something with somebody and you press charges against someone for sexual harassment. The internal committee finds out there may be some internal CCTV recording or something like that, which shows that what you are saying is totally untrue and you are making false allegations against somebody. In such a situation, you have also to be prepared to face the reverse music, because if you make a false complaint against somebody, there is a big possibility of that person's entire life's hard work getting washed out. So be very, very careful. Do not make any false complaint about anyone. If there is a genuine complaint, if there is a genuine concern, of course, you can raise your concern. What are the consequences for the person who is found guilty of sexual harassment? Suppose an inquiry is initiated, everything is done, all evidences are laid. Depending on the severity of the offense, the IC can recommend anything from fine, transfer, or termination. If the Posh policy or company guidelines explicitly provide for a certain action, that will be followed. The IC can also order for compensation to be paid to the victim, taking into consideration various factors such as loss of career opportunity, mental trauma, pain suffered, medical expenses suffered for psychiatric or physical treatment. Is the Posh Act gendered? Certainly, yes, it is gendered. The Posh Act provides only for women to complain about sexual harassment in the workplace, the gender of the person against whom the complaint is given is not specified. However, in the recent times, organizations are expanding on the Posh Act and coming up with their own policies against sexual harassment in the workplace. These policies are gender neutral, and some of them also offer additional protection to LGBTQ individuals who do not focus on gender binaries. So this is one of the feature. Now, what do you do if your company has not published the Posh policy? Nor do I know the members of the IC what can I do. If your company has more than 10 people working and has not complied with the Posh Act, you can start by sending an email to HR and superiors about Posh policy and the list of IC members. Some workplaces may be defensive when employees ask about compliances, and if other colleagues also demand the same information, the management will be likely to respond as there is strength in numbers. If there is a union in the workplace, you can route your concerns to them as well. There are concerns to employers who do not comply the Posh Act that range from a fine, doubling the fine amount, to losing their license or approval. Further, companies have to make a statement in their annual report that they have complied with consulting and IC under the Posh Act. And they also have to send annual returns about compliances under the Posh Act. So nowadays, if suppose you are working in a company, there are more than 10 employees, you can demand, make a Posh policy available for me, create an ICC. My company does not conduct training sessions with respect to Posh policy. Are they supposed to do that? It is mandatory for employers with more than 10 people working in the organization to conduct an awareness and training program for sensitizing employees with respect to Posh Act. I believe this is what we are doing today, that we are sensitizing and we are creating awareness with respect to this Posh Act. They are also supposed to display company's Posh policy at conspicuous place and circulate the list of IC members with the contact details. The employee is entitled to demand this at the workplace. So I've already discussed whether this extends to online. Yes, it extends to online work. Now, what is the objective? Posh law is enacted with the objective of making workplaces safer for women by preventing, prohibiting, redressing acts of sexual harassment against them in the workplace. One of the compliance of the law is creation of the Internal Complaints Committee. Now, I have already explained what is the structure of this. Any employer or workplace with 10 or more employees is required to constitute ICC. As reported recently in a statement by the Women's Commission for Maharashtra, they will take stringent steps against offices if they are found violating the guidelines laid down by the Prevention of Sexual Harassment in Workplaces. A team of the Women's Commission will now pay a surprise visit to companies to check if an ICC has been formed or not. A penalty of rupees 50,000 will be levied if there is no such committee. Maharashtra State Women's Commission Chairperson Rupali Chakankar has written a letter to the Secretary of the State on 10 November 2021 regarding the same and has asked the companies to be given directions to have ICCs. In a recent judgment, Arvinder Bagga and others versus Local Complaints Committee of 2017, the Indore bench of the Madhya Pradesh High Court has slapped a penalty of 50,000 on Medanta Hospital in Indore. So there is a hospital called Medanta, is a famous Medanta group in Indore, for not having internal complaints committee under the Sexual Harassment of Women's Workplace under the Posh Act. The court has also directed the hospital to pay a compensation of rupees 25 lakhs to the complainant for failing to address her complaint of sexual harassment. The order was passed in concurrence with a report filed by the Local Complaints Committee of Indore. So, in this case, Arvinder Bagga of Indore, the Madhya Pradesh High Court made the Medanta Hospital pay 25 lakh rupees. So what can be done? Annual report sent by the ICC to the employer and district officer containing details of sexual harassment proceedings can be sent. Sexual harassment must be recognized as a form of misconduct in the organization. Display of posters, notices in prominent places in the premises of the organization informing employees about zero tolerance towards sexual harassment. Share the posters and Posh policy among all employees virtually in case of remote working. Sensitization workshops and seminars must be organized to inform the employees about their rights. Capacity building programs for members of the ICC. Posh policy should be made applicable to all the offices, including the main branch of the organization. Okay, so I have explained to you the workings of the ICC. What powers does ICC have? The ICC, the Complaints Committee, have the powers of a civil court for gathering evidence. Very important. They have the powers near or equal to civil courts for gathering evidence, which means the evidence has to be gathered as per the procedure laid in the Indian Evidence Act. The complaints committee are required to provide for conciliation before initiating any inquiry requested by the complainant. Penalties have been prescribed for employers. Non-compliance with the provision of the Act shall be punished with a fine. Repeated violations may lead to higher penalties, cancellation of license, registration, etc. Now, I'm talking about a recent development with regards to Posh Act. Many of you may be aware of it. Recently, a petition has been filed in the Supreme Court challenging guidelines issued by the Bombay High Court under the Posh Act. These guidelines were formed by Justice G.S. Patel of the Honorable High Court, Mumbai High Court, ostensibly to protect the identities of the parties in a case under the Posh Act. So, in this situation, the court realized that maybe the identities of the person involved in such kind of offenses is required to be protected. The guidelines mentioned a slew of guidelines related to conducting hearings, passing and uploading of orders reported and reportage on case of sexual harassment of women at workplace, and made it clear that such cases can be either heard in camera or in the judge's chamber, and no reporting without the nod of the judge will be permitted. Must have been some very important case where the entire credibility of the accused must have come into place. And that is why Justice G.S. Patel, Honorable Justice G.S. Patel, may have decided to pass these guidelines. The court has observed that any breach of these directions would amount to contempt of court. Now, the plea in the top court challenged this High Court decision, terming the direction as a death blow to the freedom of speech and expression enshrined under Article 19. Article 19, as we all know, gives freedom of speech. So, if I am a reporter and if a very important case comes up for hearing under the Posh Act, and I decide to report it so that some awareness is generated. So, in such a situation, I have that liberty under Article 19 for freedom of speech. Now, what is basically these are Posh Act is an extension of Vishayaka Guidelines introduced by the Supreme Court in Vishayaka and others versus State of Rajasthan, which had laid down guidelines for dealing with sexual harassment in the workplace. Posh Act has been implemented with an aim to prevent and protect women. Section 2N of the Act defines sexual harassment. I have already gone into that. The Act also covers concept of quid pro quo harassment and hostile work environment as forms of sexual harassment if it occurs in connection with an act or behavior of sexual harassment. Aggrieved woman in relation to workplace is a woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment. This has come from Bhavri Devi's case. The Posh Act applies to both the organized and unorganized sectors in India. Any society that fails to harness the energy and creativity of its women is at at a huge disadvantage in the modern world. So every society must harness the energy and creativity of a woman. Women comprise almost 50% of the population of India and are now seen to be working in almost all sectors and areas. There is a presence of women in the jobs areas which were earlier considered to be exclusively reserved for men. Women never dared to choose such areas as their profession. This positive change in the society was followed by a series of horrifying incidents where women were raped, harassed by men, women were treated as objects, and so and so. This violated the fundamental rights of the woman provided under the Constitution of India. Now, coming to the main historical background, why this case of Bhauri Devi is so important and why the terms Vishaka Guidelines. So, Vishaka was an NGO, a famous NGO. So, what they did, they brought into limelight this entire Bhauri Devi case. The Bhauri Devi is one of the most significant cases among the cases of women safety, as it paved way for this Vishaka Guidelines. Bhauri Devi was a Dalit government employee. Earlier, I read Posh Act applies to both organized and unorganized sector. So, as per the Act, an aggrieved woman in relation to workplace is a woman of any age, whether employed or not. Here, Bhauri Devi was a Dalit government employee who was engaged in spreading awareness about hygiene and education and running campaigns against dowry and child marriage. As part of her employment, she was helping a young girl who was forced to marry at the young age by her parents. However, there were powerful political personalities, influential people involved, and she failed to stop the child marriage from happening. She tried to resist and carried out a rally, but she was not able to stop the marriage. In order to take revenge for the rallies and campaigns, a group of people attacked Bhauri when she was walking along the road with her husband and she was gang raped. Now, after this heinous crime, naturally Bhauri Devi filed a criminal case of rape against this man. Rajasthan High Court convicted the 5 men of assault whose degree of punishment is much lesser than the crime of rape. Initially, the police were not ready to even take the case. Judgment by the Rajasthan High Court gave rise to a series of rallies. The general public, the protesters were lathi charged by the police. However, the crowd did not stop protesting. The people were determined to force the government and legal system to provide justice to Bhauri Devi. Now, Vishaka was a group of non-profit organizations who worked towards the safety of women, filed a petition in the Supreme Court of India seeking justice for Bhauri, thereby the appropriate punishment for men involving in gang rape. They filed public interest litigation in the name of Vishaka and contended that the fundamental rights of Bhauri Devi were violated. They also sought a new set of guidelines for the protection of women. The NGO also mentioned the point of safety of women at workplaces in the PIL filed owing to the fact that the employer of Bhauri Devi did not accept any responsibility, though the reason that Bhauri Devi was raped was due to the work that she was supposed to perform. Now, you may say, how is a gang rape related to a workplace? I mean, she was walking on the road with her husband. Yes, she was walking on the road with her husband, and in a normal circumstance, maybe she may not have been gang raped. But because she was part of a campaign by the government, and in course of her employment, she was supposed to perform as part of her employment. Hence, the PL sought to develop new set of guidelines for the safety of work, women at workplace. Judgment was given by 3-judge bench. Normally, in regular cases, there is always a two-judge bench, but here there was a 3-judge bench which held that fundamental rights provided under Article 14, Article 15, Article 91G, and Article 21 of the Constitution of India are violated by the Act of Sexual Harassment. The court brought out the Vishaka Guidelines for the protection of women at the workplace and providing a safer working environment to the women. Vishaka Guidelines over a set of guidelines that were intended to protect the woman at workplace. These were instituted by the Supreme Court in the year 1997. These are procedural in nature and state the method that is to be followed while dealing with cases related to sexual harassment of women. Now, earlier, prior to this Vishayaka guidelines, there were no rules regarding obligation of an employer to provide support and assistance to the employee who is victim of sexual harassment. The employers would throw these women victims out of the jobs. So if any woman would complain, she would just be removed, fired from the job. The employers would throw these women victims out of the job and escape their liability of further consequence. This would leave the victim hopeless and unsecured. With the growing number of crimes against women being reported, there was an urgent need for a new set of laws that punishes the wrongdoers and ensure that women are protected at their workplace. But a new set of legislation would take a lot of time. Thus, Vishayaka guidelines came into existence to provide a set of guidelines to prevent sexual harassment of women. So naturally, when these guidelines were drawn in 1997, so consider the amount of time that has gone. See, 1997, this act is of 2013. So a considerable period of time lapsed. And until then, these guidelines that were provided by Vishayaka case, which are known as Vishayaka guidelines, they helped in all such cases. Now, one of the key aspects of this is also that there is a duty enshrined on the employer to file a complaint. Not only does the employer have to provide a safer working environment, but also there is a duty cast on the employer to file a complaint. The guidelines also lay down the obligation of the employer to file a complaint if the conduct towards an employee amounts to criminal offense, which is punishable under the Indian Penal Code. The employer needs to initiate an action and ensure that the witnesses are not further victimized. Say, suppose there is a incident that has happened of sexual harassment, and there are few witnesses to this. So the duty is cast upon the employer to immediately inform about this incident to the concerned police station. Now, the concerned police station has a duty also to register an FIR and immediately take action. So, if this is not done, then the employer can also be understood to be a person who is an abettor, one who abets any crime. You are trying to shield some accused, then you are also part of the crime. Complaint redressal committee, the guidelines make it mandatory for all organizations to set up a complaint redressal committee in order to ensure that the complaint of the employees are dealt with properly and suitable action is taken in response to such a complaint. Employer to assist the employee if she is sexually harassed. If the employee is sexually harassed or tortured by a third party, like in the case of Bhauri Devi, an employer should assist the employee in every possible manner, since this was not the case in Bhauri Devi. Bhauri Devi, the employer denied all responsibilities and did not assist her in attaining justice. So that is why the Supreme Court then decided to pass these guidelines. It is also the duty of the employer to spread awareness with regard to the matters pertaining to sexual harassment and safety of women. This can be done by notifying the employees time as well as conducting workshops and devising other interactive ways to make the female employees aware of their rights. Duty of government to widen the scope of these guidelines. There is also a duty cast on the government. The guidelines also urge the center and the state government to pass the necessary legislation so as to ensure that the private sector is also bound by these guidelines. This will help in the growth and prosperity of women as well as the nation as a whole. Now, let us conclude. This entire Posh Act the Constitution of India is the supreme law of our country and must be protected and respected in every instance. The fundamental rights of equality, personal liberty should be protected, and citizens of our country should not be discriminated against on any grounds. Hence, it is legal as well as a moral duty to provide a safer work environment for women to prosper. Vishayaka guidelines are a set of guidelines that were instituted by the Supreme Court to ensure the safety of women. Vishayaka guidelines also pioneering step to ensure the safety of women. I am just summarizing quickly. Now, as I told you, that there has been a recent development in Posh Act, and I'm sure many of the study materials available will not include this kind of development. I informed you about a petition that has been filed in the apex court, in the Supreme Court, challenging guidelines issued by the Bombay High Court by Honorable Justice J.S. Patel. Now, in this, as I said, there was a blanket bar. Now, what do I mean by a blanket bar? A blanket bar is where a kind of shielding is given by the court. The court says, I'm shielding, I'm giving a blanket bar to the person who has been accused on parties and advocates from sharing, recording, including orders and judgments with the media. A petition was filed by Advocate Abha Singh, and this petition was argued on 24th September 2021, and order of single bench of the High Court, and it says that this is a death blow to the freedom of speech and expression enshrined in Article 19. The petition said, a well-informed citizenry governs itself better. See the words. Well-informed citizenry governs itself better. Now, words are very critical in any petition. So, in a way, they are saying that a right to free speech can be curbed only if it interferes with the administration of justice. Any injunction on the right of the people to know the true and accurate facts is an encroachment on the right to their information. So, in matters of social justice and women empowerment, public discourse plays a crucial role in shaping the nature of legal entitlements that are delivered to women. High Court order may have a ripple effect and deter survivors from approaching court, as well as setting a dangerous precedent for trial cases. The same will legitimize undue protection to sexual offenders in gross violation of principles of open court, natural justice, fundamental rights of the survivors. Guidelines were formed by Honorable Justice G.S. Patel of the Honorable Bombay High Court, ostensibly to protect the identities of the parties in case of a Posh Act. Now, this Miss Abha Singh also argued that the High Court order violates the principles of open court as enshrined in the Swapnil Tripathi judgment. Now, there is a very important judgment called Swapnil Tripathi judgment, where the issue of open court was discussed. In many of my cases also, I have referred this Swapnil Tripathi judgment. Open court is a concept where naturally all the people who are involved in a set of crime have an opportunity to be heard by the public at large. So that is why this single bench passed a strict guidelines giving a blanket bar. Now, you cannot publish about a sexual harassment at workplace situation in anywhere. No reporter is allowed to publish. Now, this entire thing was argued on September 24, 2021. We are in 2022 February now. Still, the issue is pending in the Supreme Court. Nobody knows when there will be a final decision taken by the Supreme Court. But the woman who has approached the Supreme Court through a SLP. Now, what is a SLP? Is a special leave petition. Is the original plaintiff of the Bombay High Court case, Advocate Abha Singh, on behalf of the plaintiff, said that the High Court order suffers from grave irregularities. It will legitimize undue protection to sexual offenders in gross violation of principles of open court, natural justice, and fundamental rights of survivors. The petition draws attention to the importance of public discourse in shaping the nature of legal entitlements. And there are various landmark judgments also, which have brought changes in the entire scenario of women harassment. The entire scene of the rape laws in India. Today, there are various changes that are taking place on a daily basis. The legislature has to take note of growing concerns about women's safety. So I think I can conclude this. Here we had a long discussion today, and I don't want to exhaust the entire time that is given to me. I will also request if there are any questions related to this act. If someone wants to have any question, you can ask me. All right, Aarti ji.
Yes, sir. Really informative and insightful session, I'll say. And it's you explain it very well because I'll say apart from me, 2, 3 people will be from law background who can understand the sections and everything. But I think everyone in this session would be able to understand because of your explanation, the
Thank you so
how the
much.
procedure and what petitions and everything. Thank you so
See,
much, sir.
I have always believed that any explanation should be very lucid. The explanations given by, see, we have to convince the judges, right, in a court of law. And as professors and lecturers, we have to convince the students. So the explanations must be very lucid, simple to understand.
Yes, sir. Yes, sir.
Yes. Yes.
Uh-huh.
So I again thank everyone, Dr. Alka ji and Vaishali Ojha ji and everyone involved in the team. I can take some questions if they are.
Yes, I was gonna ask you, sir. Can we take some questions?
Yes, because I think I will have to wrap it up very
Okay,
quickly.
okay, very
So
quickly. Two questions, max 2 questions. Okay. Participants, if you have any question, you can raise your hand. I'll unmute you. Or you can put in the chat box. So one question is there on a YouTube because we are having a YouTube live as well.
right.
So I have received one question. You have answered it, but it's a question, so it's better to answer. It's
Yes.
related to, sir, if I see violence around me, and the female is deprived of complaining or she doesn't want to complain, can I complain instead of her? She doesn't want to, but can I do?
See, you can complain, but whether that will go under Posh Act, I don't really believe, because Posh Act very clearly, I have said in the very beginning, it requires a written complaint. The complaint cannot be an oral complaint also. It has to be a written complaint where you are writing and informing the ICC that such and such thing has happened with me. So basically, it empowers the victim itself. But if the victim does not want to come ahead and say you are a person who is a witness to this, and you feel that you want justice for the victim, and you have, say, a video recorded. So if you have quickly recorded a video on your cell phone and it is a genuine. So nowadays, when you go to a court for any to bring ahead any evidence, digital evidence especially, you require a certificate under Section 65B of the Indian Evidence Act. And once you have that certificate of that evidence in your hand, digital evidence, then you can file an independent complaint under the IPC also, saying that, see, such and such situation has happened. I am a witness to this. And because of this, I feel that the victim who is not mustering the courage to come up to file the complaint, I want to file this complaint. I can't tolerate this nonsense.
So there are two questions,
Yes.
two more to that. One is they have, I'll read it. If I file a complaint, everyone in the workplace will come to know, and I don't want to deal with it. What can I do in that case?
See, the ICC has, as I said, has a responsibility to maintain confidentiality. That is one thing. And if you don't want justice, nobody is forcing you. See, when you want justice, you have to be bold.
Very true.
You cannot be subdued in your thoughts and then believe that the person who has committed the crime will automatically come to senses. Nobody comes to senses like that. In life, you have to fight, you have to struggle, and you have to voice your concern to get justice. Especially in, I might take, if I'm allowed, maybe
Yes,
next
sir.
time I may do a session on how today it is very difficult for litigants to get justice through courts. It is a very alarming situation on how many number of cases that are pending in India. But having said that, if you are a person who feels that your privacy will be disclosed, then it is the responsibility of the members of the ICC, the Internal Complaints Committee, to protect your identity. Of course, and as I said, whether you can spread about your case on the Instagram and other on WhatsApp, and you cannot do that. You have to maintain your own privacy. Write a confidential letter to the ICC and wait. 90 days period is there for the entire complaint to be resolved.
Sir, last question.
Yes.
It's evidence. It's from the evidence point of view they want to ask.
Yes.
It's basically asked, isn't there is a need for an evidence for the case of stalking? And if in that particular case, what kind of proof we can submit to the case?
This is a question not related to this topic, Posh Act, but I will answer it nevertheless. See, stalking is something relatively a new phenomenon. Earlier, Indian Penal Code did not cover stalking at all. I mean, I'm not. All these sections were added, I think, in 2013.
Yes, sir.
So the point being, when suppose you don't have an evidence of somebody stalking you, you can create your own evidence. Say, in one of my cases, I got the lead of a client who said that, see, someone is following me. I said, what evidence do you have? Which normally any advocate will ask the same question. So the woman said, see, sir, I am seeing with my own eyes that when I drive a scooter from one place to another place, from point A to point B, a particular vehicle follows me every day. I said, that may be his timing and your timing, correct? You both may have the same time. Then she said, no, sir, whenever I decide to wait for a particular time at a particular place, and I've done that 4 or 5 times, I particularly at a place I waited for 20 minutes, that fellow also waits for 20 minutes. So in such a situation, what I advise her, you send a court person, her own husband sat with a video camera on a motorcycle, much behind, he hid behind a tree, and he started to video record the entire thing. So there was a video recording created where not once but thrice this person, whenever this lady passes on a scooter, he starts the vehicle and follows her to a particular destination, and then he just observes her. So I told him to record his face, to record the direction in which his eyes are going, and everything was recorded and neat evidence was created. So in such a situation, if you are a victim of stalking and you don't have any evidence, create the evidence. There is no other way. It is my suggestion to all the victims of stalking to become bold, to
Yes,
take.
because
Hmm.
sir, our girls, mostly girl students are facing that. That's why I took the question, and they always asked, "Ki what
Hmm.
can be done?" So, really,
I
thank you,
think
sir.
this is the best thing
Hmm.
that can be done. Generate the evidence.
Hmm.
The evidence should not be fabricated for one, and the evidence should be clear. I always recommend all my clients to have a video camera which has capacity of above 5 megapixels. Now there are this is an old thing because in court usually when we produce evidence, if the resolution is below 5 megapixel, the courts do not entertain it. So kindly note this.
Yes. Thank you so much. Good things comes to an end. So this session. Now I'll request our presiding officer, Dr. Alka Vadhwana, to propose a formal vote of thanks. Over to you, ma'am.
Thank you, Aarti. And good afternoon to everyone present here. It is an honor to be asked to propose a vote of thanks for this event. I, Dr. Alika Wadwana, on behalf of K. Shroff College and ICC, would like to thank our management, without whom this event would not have been possible. We are grateful to our principal, Dr. Lili Bhushan, and vice principal, Dr. V.S. Kannan, for their constant support and motivation. I extend a very hearty vote of thanks to our speaker, Advocate Amol Sutrale sir. I am thankful to Advocate Bhavna Jadhav for sharing the contact details of Advocate Sutrale. I am blessed with a very motivated and dedicated team members of ICC, especially Dr. Vanitha Isaimani, Samita Singh Gupta Madam, Manish Singh sir, Vaishali Oza, and Aarti Gadri, who know their responsibilities and they are result oriented too. I would like to express deep gratitude to all the teaching and non-teaching staff, especially my library staff, for their generous support. I would like to express a big thank to my assistant librarian, Jasmine Kadam, for preparing beautiful flyer for this event. I am thankful to the student representatives of ICC, Ms. Tanvi Sharma, Dolu Mehta, Sai Raj Ghag, and alumni representative Purvi Rathod for providing technical support as well as assistance in conducting this event. This event would not have been possible and could not have been on YouTube without the help of our social media in charge, Ms. Rashi. I am thankful to her. Last but not the least, we appreciate the patience and enthusiasm of our participants who made this event a grand success. As we come to an end of this lively gathering, I thank each and every one of you for being the part of this event. Thank you very much. Thank you, Amol sir. Thanks a lot. It was very exhaustive and in a simplified and lucid manner, you explained all the laws and working of ICC also. I'm very thankful. Without PPT also, we could not able to move here and there, and because we wanted to listen. Thank you very much.
All right. Thanks for having me. And whenever you decide to have any future lectures, and send me the topic, we'll see.
Thank you. Thank you very much for your support. Thank you. We will be in touch, and many more programs we can arrange in future. Thank you, sir. We can end the meeting now.
Ma'am, we will wait for 5 minutes to our participant to fill the feedback form.
Have you shared the feedback link?
Yes, ma'am. Yes, ma'am.
On YouTube also.